So I want to welcome everyone who's joining us today in our fantastic lineup of speakers. I'm Emily Broadleave, and along with Professor Martha Minow, I'm hosting this colloquium series throughout the semester. Professor Minow and I developed this weekly series as a forum for discussing many of the ways in which legal rules and practices are being tested and are responding to the challenges brought on by COVID-19. So the goal has been, and we've been successful in doing this, bringing together members of the Harvard Law School community while we're all remote in order to explore and assess the legal response to COVID-19 across a range of areas of law, including health and healthcare law, regulation of labor, safety, finance, debt, prisons and criminal justice, immigration, human rights, election law, and the scope and limitations of governmental powers in this unprecedented time. We're particularly concerned with and talking about issues of how the pandemic especially burdens marginalized communities such as Black, Latinx, Native American, and other people of color, and Americans living at the margins, and trying to examine how the pandemic shines a spotlight on these inequalities and disparities, and how law and policy decisions have shaped and continue to shape the response. Just a thank you to Professor Minow for her partnership and inspiration working on this together, to Dean Manning and the law school for supporting this, and to our amazing speakers today and throughout the series and the teaching fellows that are helping us make this possible. I want to say just a word about the election and for today in particular, as here we are in the midst of counting votes in this election and seeing where it will pan out. I want to thank our incredible speakers for making the time to be here, and those of you who are joining us live for making the time to join, given that I know many people were up late and are nervously checking the news for election updates. I don't think it's out of line to say that here at a law school, we're all anxiously watching the outcome of the election and trying to read the tea leaves as to how it will impact many of the issues we're going to discuss today and that we've talked about throughout the series. So we have a really amazing lineup of speakers today. We have a really full set of issues to talk about. And while the ongoing kind of election results won't change the topic for the discussion, I anticipate that our speakers, while sharing their expertise, will also at least speak briefly about how the outcome of the election might impact these important topics. And I also want to remind those that are here today about an opportunity that we're making available thanks to Professor Rachel Viscomi and the Harvard Negotiation and Mediation Program, that they're hosting small group facilitated conversations on topics in the colloquium series, including today's topic, and those take place on the day after the series. So the discussion for today's colloquium series will take place tomorrow, Thursday, from 3 to 4:15. If you are interested in joining for this week or for next week, you can email Professor Viscomi. Lastly, as a reminder, the session is being recorded. These sessions and then a blog that relates to many of these topics is available on our website, which is at covidseries.law.harvard.edu. Students are writing blog posts for credit, and we have now made that available as well during winter and spring term. And you can email Professor Minow or myself if you're interested. And we hope that you'll ask questions using the Q&A function at the bottom, and we'll be able to take those. Thank you for indulging my longer than usual introduction. I now want to just say I'm really excited to hear from our amazing lineup of speakers. I'm just going to quickly introduce our moderator, who's doing double duty as both moderator and speaker, Professor Bill Alford, who is the Jerome A. and Joan L. Cohen Professor of Law, Director of the East Asian Legal Studies Program, and Chair of the Harvard Law School Project on Disability. He's an amazing scholar of Chinese law and legal history, the founding chair of the Harvard Law School Project on Disability. He's the senior advisor for the Graduate in International Legal Studies program here at HLS, and has served as consultant and advisor to many multilateral organizations, various offices of the US government and members of Congress and foreign governments, and just brings such a wealth of knowledge. And I'm so glad and grateful to you for both moderating and speaking, and to our other speakers today. So thank you again.
Thank you, Emily, and thank you, Martha. It's a delight to be here. So I am joined today by two other wonderful colleagues. Jerry Neuman is the J. Sinclair Armstrong Professor of International, Foreign, and Comparative Law and co-director of our Human Rights Program. From 2011 to 2014, Jerry was a member of the Human Rights Committee, the treaty body of independent experts who monitor compliance with the International Covenant on Civil and Political Rights. At the time of Jerry's election, Martha Minow wrote, quote, Jerry Neuman has not only deep expertise in international human rights law, but also superb judgment, an impeccable sense of fairness, and remarkable powers of analysis, as you will hear. Sabi Ardalan is also a wonderful colleague. She's clinical professor and faculty director of Harvard's Immigration and Refugee Clinic. She teaches courses on immigration law, US asylum law, international refugee law, international labor migration, and she's a wonderful and inspiring cross-disciplinary teacher. As the founder of that clinic, Debbie Anker wrote at the time of Sabi's appointment, Sabi has that extraordinary combination of commitment to clients, the immigrant community, and brilliant appellate advocacy and scholarship. And I have to say, at a personal level, I have profound gratitude to Sabi for the many people she's helped throughout the Harvard community and beyond. So our panel today is pretty far-ranging, and so we decided to start with the broadest at the global level, and then work through back a little more to the domestic, though you'll see that all of us are touching both on matters international and matters domestic. So I've been selected to go first. So the pandemic has laid bare many of the glib rationale that have long been offered in support of unfettered globalization, while also exposing the inadequacy of many multilateral institutions that were intended to address the implications of globalization. The assurance with which many for decades have asserted that the interdependence engendered by globalization is essentially an unalloyed good today seems naive at best. Consider, for example, the tens of millions of international air travelers in the early months of the year contributing unwittingly to the spread of the virus, or think about the consequences on our social fabric here in the US of our failure to share enough of the benefits of globalization of trade with our fellow citizens so as to ensure access by everyone to decent medical care, sick leave, childcare, and so forth. Now, the deep structural flaws in multilateral institutions are most vividly borne out by the World Health Organization. Notwithstanding 7,000 professionals in 150 offices around the world, the WHO fell woefully short when it was most needed. Too often, it allowed politics to temper its public health mission, as in praising China in spite of Beijing's failure to meet its WHO reporting requirements back in the early stages of the pandemic, and in downplaying the possibility of human-to-human transmission. Now, noting these shortcomings is not to excuse Beijing's lack of transparency, nor Washington's woeful performance. It is a sad but telling commentary on the WHO that the government widely considered to have done the best job worldwide in addressing the pandemic, that of Taiwan, is excluded from the WHO thanks to Beijing's pressure. Indeed, one doesn't need to be cynical to say that that exclusion from the WHO is a principal reason for Taiwan having done so well, as it relied on its own data rather than more politically compromised medical information from the WHO. Other relevant multilateral organizations have also generally not risen as fully as one would hope to the task. The UN itself, which could have played more of a coordinating role given the human rights, security, economic, health, and other implications of the pandemic, has been somewhat missing in action. The G20, the World Bank, and the IMF, International Monetary Fund, have taken some measures to ease sovereign debt repayment, but vastly more remains to be done. And no one, not even the impressive UN World Food Program, recipient of this year's Nobel Prize, Peace Prize, has been able to penetrate our absorption here in the US or in Western Europe with our own situation enough to drive home the potential that COVID has to overwhelm health services and spark famine in parts of the global South. Although it is worth noting that because of that very prospect of overwhelmed health systems and famine, several governments in Africa have actually done a better job than we in the US of enlisting public support for important preventative measures such as masking. Now, the Trump administration's response to all this has been to double down on its repudiation of multilateralism. Its triggering of the one-year notice required by US law to withdraw from the WHO and its withholding of about $62 million of funds due from the US are the most publicized instances, but no less crucial is its refusal to take part in the COVID-19 vaccine global access facility known as COVAX. This global public-private partnership is intended to bring nations together to achieve three purposes. First, to support development of several different possible vaccines. Secondly, to foster procurement at scale to lower costs for everyone. And third, to promote equitable distribution of vaccines worldwide so that developing nations are not left out. Importantly, COVAX does not preclude the economically more advanced countries from continuing to take other measures to sponsor additional vaccine development or to ensure that their own citizens are fully protected, which may explain why more than 170 nations, essentially every major country except the US and Russia, has joined COVAX. We need to keep in mind, as I make these comments about the Trump administration, that its failure to see the importance of collaboration has taken to an extreme what is really a long-standing dimension in American life, far preceding this administration. Fact is that from the time of George Washington's farewell address onward, the US has displayed a profound ambivalence about international engagement. On the one hand, promoting international entities and agreements, on the other hand, often not joining or withdrawing or otherwise impairing. One could think, for example, quickly just to offer a few illustrations of the League of Nations, UN Convention on the Law of the Sea, UN Convention on the Rights of Persons with Disabilities. To be sure, as I will mention later in my remarks, there are some stellar examples of US engagement, but it's important to see this as an issue or problem that, again, long precedes the Trump administration. Now, the case for taking part in COVAX rests as much on self-interest as on altruism. As long as COVID-19 remains anywhere, it's a threat everywhere, as the recurrence of outbreaks, even in places that have handled the pandemic far more effectively than us, bears out. Think, for example, of South Korea, Hong Kong, or Canada. Moreover, there is no certainty that vaccines being developed in the US will necessarily be better than non-US alternatives included in the pool receiving COVAX support. And crassly, it surely cannot be in US national interest in terms of security or economic matters if the pandemic rages in developing countries, possibly leading to instability, famine, and population dislocation. Now, there also is a compelling case for addressing what ails the WHO more broadly. COVID-19 is but one of what are said to be perhaps thousands of easily transmissible, deadly viruses out there. And even with massive retrenchments these days in air travel, globalization is not going away, nor should it when one considers the benefits we might reap from it, so long as we are candid about its shortcomings and mindful of our shared humanity. Improving the WHO will not be easy because its flaws are as much features as they are bugs. First, the organization is an uncomfortable mix of science and international relations. when the latter bleeds too much into the former, as it did when the WHO praised China instead of calling it to task for not meeting its obligations under the WHO's 2005 international health regulations. The results are both an immediate problem in the sense of inaccurate advice being given, and also fuels growing skepticism about the importance and reliability of expertise. Second, the mandate in the international health regulations that all countries build a public health infrastructure that will enable them to address health crises and to notify the WHO in a timely way of outbreaks is largely an unfunded mandate, with the result, for instance, that no African nation is in full compliance. This is owing to a third problem, that the organization is grossly underfunded, with a per annum based budget of less than half of the US CDC, and with some 80% of that budget coming from private philanthropy or voluntary payments by member states rather than assessed dues. This has meant that at times donor-funded projects, donor-favored projects, although very valuable, have tended to be the ones supported rather than less glamorous but crucial capacity building in developing nations. Now, lying at the heart of all this is the desire of states, and especially big states, to guard their sovereignty and guard their purses. As the late diplomat Richard Holbrooke once put it, blaming the UN for failing to address a global problem is like blaming Madison Square Garden, the basketball arena, when the New York Knicks basketball team plays poorly. Of course, one can understand why the US or China, for that matter, are reluctant to agree to independent monitoring of IHR compliance or meaningful enforcement by the WHO or some other entity. And one can appreciate that in a time of enormous competing demands domestically, the idea of stepping up financial commitments abroad probably seems unrealistic. But the fact is that the failure to have made WHO a stronger institution and to fund it accordingly has had a vastly greater impact on our sovereignty than putting some teeth in the IHR, the International Health Regulations, and certainly has cost us vastly more than the payment of adequate annual dues would have been. And although China seems to have experienced less harm domestically than the US, its chief foreign policy undertaking of the past decade, the so-called Belt and Road Initiative, and its reputation more generally, surely have suffered greatly, given the havoc that the virus has wrought in so many other nations. Now, to try to end on a slightly more upbeat note, although it is improbable, more constructive American engagement is not out of the question. It was less than 20 years ago that the US launched the President's Emergency Plan for AIDS Relief, PEPFAR, which, enlisting WHO technical expertise, grew into an $80 billion effort to address AIDS in Africa. PEPFAR and the Bush administration's malaria initiative each might have been a little better had they been less unilateral, but the fact is that the former has ended up supporting some 15 million people on the African continent with HIV/AIDS, and that the latter has contributed importantly to cutting down on instances of malaria sharply. And remember, this was all in a Republican administration. And in 2014, the US and China were able to team up to play a critical role in stemming Ebola, this time in a Democratic administration. So I thank you for hearing me out and look forward to your questions and turn the floor over to Professor Neuman.
Thank you, Bill. I'm going to continue the theme of political compromise of medical agencies, this time at the domestic level and in relation to vulnerable migrants. One prominent feature of the current administration's response to the COVID-19 pandemic has been the political abuse of public health authorities and rationales. The manipulation of the Centers for Disease Control and Prevention to provide a medical veneer for political policies is notorious. Less well known to many Americans may be the ways the pandemic has been instrumentalized for the administration's anti-immigrant agenda. This includes a variety of presidential actions blocking immigration under the statute 8 U.S.C. section 1182F, which is the same provision of the immigration laws that was used in 2017 to adopt the Muslim ban. This includes the suspension of entry under most categories of immigrant visas in April of 2020, justified in relation to the economic consequences of the pandemic, and later the suspension of entry under temporary work visas in June of 2020 with the same justification. But this technique can only be used against non-citizens who have not yet entered the country. The main issue that I'd like to talk about today isn't the use of the immigration laws at all. It is the abuse of the CDC to create a shadow immigration enforcement system in order to circumvent the immigration laws and abolish refugee law in the Southwest, as well as statutory protections for unaccompanied non-citizen children. I should disclose that I have joined amicus briefs in some of the litigation about this, along with Professor Anker of the Harvard Immigration and Refugee Clinic and two other leading refugee law experts. Over the past few years, the Attorney General and the Department of Homeland Security have adopted numerous policies under the immigration laws designed to undermine the rights of asylum seekers and have treated children caught up in the immigration system ruthlessly. But the White House saw in the pandemic the opportunity to shut down asylum altogether. I'll use the term asylum here as a shorthand for statutory guarantees of protection from persecution, torture, and death, as required by acts of Congress that implement US treaty obligations. On March 24th, at a time when the pandemic was much more serious in the United States than in Mexico and Central America, the administration got the CDC to issue a regulation and an order redefining its authority to prohibit introduction of persons and goods that might spread communicable diseases. The purported basis of this regulation is an old provision of the Public Health Service Act that deals with foreign quarantine. 42 U.S. Code Section 265, entitled Suspension of Entries and Imports from Designated Places to Prevent Spread of Communicable Diseases. Please bear with me as I read you the language of that section. Whenever the Surgeon General determines that by reason of the existence of any communicable disease in a foreign country, there is serious danger of the introduction of such disease into the United States, and that this danger is so increased by the introduction of persons or property from such country that a suspension of the right to introduce such persons and property is required in the interest of the public health, the Surgeon General, in accordance with the regulations approved by the President, shall have the power to prohibit in whole or in part the introduction of persons and property from such countries or places as he shall designate in order to avert such danger and for such period of time as he may deem necessary for such purpose. That's Section 265. By its terms, it deals with introduction of persons and property, described in its title as entries and imports. But the new regulation reshapes the power to prohibit in whole or in part the introduction of persons as the power to arrest people anywhere in the interior of the United States and to expel them immediately to any country the United States chooses without any kind of a hearing and without any showing that they themselves pose any health risk whatsoever. The rationale for the new system, when it was adopted, was that even if individuals are healthy, they may catch the virus in overcrowded detention centers and then spread it later. To which the obvious answer is, then don't put them in overcrowded detention centers. And the CDC order delegates the power to implement this regime to the same officials who enforce the immigration law, without complying with the limits that immigration law places on them when they enforce the immigration law. The administration calls this the Title 42 process, and it is a shadow immigration system built alongside the legally authorized immigration control system. In particular, it circumvents the procedures that Congress mandated for expedited removal of people seeking protection as refugees, the prohibition of return to torture, and the special protections that Congress put in the immigration law for unaccompanied minors. The Title 42 process doesn't apply to citizens or to permanent residents or to people with valid temporary visas or to people who don't need visitors' visas. It is clearly targeted at refugees and unaccompanied children seeking protection. The administration has been using the Title 42 process since March to return children and adults to the very countries that they fled from. The ACLU brought a legal challenge to this regime in June on behalf of a teenage boy who fled threats to his life in Honduras. And a federal judge in the District of Columbia granted a preliminary injunction against expelling him, finding that he was likely to succeed on his claim that the Title 42 process was unlawful. The government then mooted out the case by diverting the boy to the normal immigration system. And then they did that several more times with other cases when lawsuits were threatened. In August, the ACLU filed a class action, leading with a Mayan boy who had fled death threats for political reasons in Guatemala. Hopefully, this class action form will prevent the government from mooting out the case. The district judge referred the case to a magistrate judge who issued a report and recommendation in September, concluding that the Title 42 process is unlawful. First, because 265 does not authorize expulsion, and second, because Section 265 must be reconciled with the provisions of the immigration law that require normal immigration procedures for unaccompanied children and that prohibit the return of refugees to countries where they would be persecuted. Currently, that report and recommendation is being reviewed by the district judge, and we will see what happens next. For those of you who have attended earlier talks in this series, I'd like to draw a contrast. The use of the CDC to circumvent the immigration laws is not the only surprising use of the CDC during the pandemic. This series has previously discussed the CDC's order delaying evictions, also adopted under pressure from the White House. That order rested on a rather liberal interpretation of 42 U.S.C. Section 264, which is the section immediately before Section 265. It reads, "The Surgeon General, with the approval of the Secretary, is authorized to make and enforce such regulations as in his judgment are necessary to prevent the introduction, transmission, or spread of communicable diseases from foreign countries into the states or possessions or from one state or possession into any other state or possession. For purposes of carrying out and enforcing such regulations, the Surgeon General may provide for such inspection, fumigation, disinfection, sanitation, pest extermination, destruction of animals or articles found to be so infected or contaminated as to be sources of dangerous infection to human beings, and other measures as in his judgment may be necessary." The policy of preventing evictions during the pandemic seems progressive, but one has to wonder if the CDC can regulate housing policy in order to avoid indirect risks of exposure to a virus. How much else of the economy can the White House regulate through the CDC? Unconstrained executive power is not an unqualified good. In closing, let me say a few words to put this in a comparative context. Now, the United States is not the only government that is abusing the pandemic for ulterior purposes. Some countries have closed their borders altogether, which the United States definitely has not. Some governments have used the pandemic as a reason to shut down asylum systems, despite the protests of international institutions. Some governments were quick to use the pandemic as an excuse to prohibit all demonstrations. Some governments have used the pandemic as a reason to postpone elections, and not just briefly. Hungary gave the executive unlimited power to rule by decree. Some countries have used the pandemic as a reason to prohibit the criticism of government on the subject of COVID, or more generally, because criticism of government is a danger to the public health. In fact, it is clear from the record of the current administration that one thing this country badly needs is a cutting back of executive emergency powers that allow a president to set aside the laws in real or fraudulent emergencies. Thank you.
Thank you, Jerry. Now on to Sabi.
Thank you, Bill. I want to talk about three sets of challenges that immigrants and asylum seekers we represent at HERC, the Immigration and Refugee Clinical Program, are facing during this pandemic, and changes to the system that would help address these challenges. With the election and the potential for a change in immigration policy, it's critical that we look at how the rights of so many vulnerable and marginalized people, including immigrants and asylum seekers, have been violated during the pandemic, and how many lives have been needlessly lost because of it. At HERC, we represent people who've managed to make their way to the US who are seeking protection. Jerry talked about the people who've been prevented from accessing the system. We're representing people who are in the system trying to vindicate their rights and yet facing incredible barriers to doing so, which have been significantly exacerbated by the pandemic. The first set of challenges I want to talk about relate to immigration enforcement during the pandemic. The second set relate to problems with the immigration court system that have been exacerbated by the pandemic. And the third set of challenges I'm going to talk about relate to the really dire situation of our draconian immigration detention system, which Jerry also referenced in his remarks. So in terms of immigration enforcement, despite advocates' efforts to have the administration halt immigration enforcement, in other words, rounding up of immigrants during the pandemic, the administration has moved forward with immigration enforcement during the pandemic, picking up as many as 2,000 immigrants in July and August, and deporting them in short order, many of whom had been in the US for decades, many of whom had US citizen children. The ramifications of this kind of immigration enforcement, especially during a pandemic, are huge. It means that immigrants who are always afraid of accessing the services they need are even more afraid of doing so. And during the pandemic, that means that their lives are at risk every day. In April, I received a frantic phone call from one of my client's daughters who was terrified because her mother was deathly ill and she was too scared to call an ambulance to have her mom go to the hospital because she was afraid of what immigration repercussions it might have if she reached out to 911. Luckily, her mom was able to get the health care that she needed and she survived, but many have not been so lucky. If immigration enforcement weren't continuing during the pandemic, if there had been a halt to that kind of immigration enforcement, perhaps more could have been done to allay immigrants' fears about accessing the services they need. It could have helped our communities stay healthy, or healthier at least. In terms of the immigration court system, the system was already broken before the pandemic. The pandemic has just made the situation worse. So our immigration court system suffers from a backlog of over 1.2 million cases right now, a huge politicization of the immigration judges, the decision making, and what that means for our clients during the pandemic is that the state of uncertainty and anxiety that they face as they go through this immigration court system has been worsened because unlike in many places where immigration courts, or immigration processing or other courts have moved to remote hearings or have put hearings on hold, have paused deportation, none of that has happened during the pandemic year, despite tremendous advocacy efforts and lawsuits to try to stop the immigration courts from moving forward, to try to stop the relentless deportation machine from moving forward. And so here in Boston, our immigration courts have remained open during the pandemic. People are being required to show up in immigration court despite the health risks to our clients, to judges, to court staff. In the last 24 hours alone, I've received 3 notices from the Executive Office for Immigration Review, which is the entity that has the immigration courts under it as part of the Department of Justice, with court closures across the country due to potential for COVID exposure. So there is no reason for these court processes to be happening in person, to be moving forward relentlessly, given the health risks at hand. And yet they are. To give just one example of the kind of havoc this wreaks on people's lives, one of my clients had her hearing on the merits of her asylum case scheduled for last month. She suffered tremendous gender-based violence, violence at the hands of gang members, and we had asked for her case to be put off. Because she has a 6-year-old son who's part of her proceedings who suffers from asthma and other serious health concerns, and she didn't want to have to bring him to court. She was ready to go forward, but was scared for his health and really didn't want to put him at risk. So we asked for a motion, we filed a motion to continue the case. We asked for it to be put on when the pandemic had abated, when there were some measures in place to keep everyone healthy and to move forward at that time. We never heard back on our motion, and so we had to keep preparing her to testify. And what does that mean in an asylum case? It means forcing somebody to relive all of the terrible experiences of their lives, to be able to give that testimony in court in front of an immigration judge, and to be able to respond to questions on cross-examination by a government attorney. And she was forced to do that preparation while in a crowded house full of relatives who she didn't want to have to hear about what she'd been through, but she had no choice. She hid in bathrooms, she hid in a car, anything to try to prepare and not have people hear. And yet it was inevitable that her 6-year-old son would hear some of it. And then the morning of the hearing, we received confirmation from the court that the judge wasn't going to be in that day, because that's what's happening in the immigration court system right now. There's complete unpredictability and uncertainty as to what cases will go forward, when judges will be there and when they won't. And so, her case ultimately didn't have to go to court, which was good news for her, but she had to go through that whole process, which could have been avoided had there been mechanisms in place to not, assume that everybody would be going forward in person in court. And she was lucky enough to have counsel, to have students working on her case to prepare her and to be ready if she had to go forward. But so many people in the immigration court system don't have that. There's a right to counsel at your own expense in immigration proceedings. Many people can't afford a lawyer. There's a dire shortage of legal services for immigrants, and the pandemic has exacerbated all of that. It's much harder to provide direct legal representation to people in this remote world. And so many people are left without lawyers and are left to navigate this utterly confusing system without any support. For people, so there are also people who are going through this immigration court process who are being forced to wait in Mexico while they do that. Their situation is even worse. So there are over 66,000 people who are waiting at the US-Mexico border who have cases that are going forward in the US immigration court system, but who are being forced to wait to pursue those claims from Mexico. And for them, the issues and barriers with access to counsel are even graver than for clients who are going through the system here in the US. They also face dire risks to their lives, threats to their lives, kidnapping, attacks on a daily basis. And the pandemic has exacerbated all of that. And the access to counsel issues during the pandemic mean that it's even harder for them to file their applications for protection in a timely manner as required under US law. So they need to file for asylum within a year, and it's been very difficult for attorneys to access their clients to move forward with those applications to get them in on time. The situation that immigrants who are in detention are facing is, I think, the most dire circumstance facing immigrants during the pandemic. So the US holds thousands of immigrants in jails, in prisons, in detention centers across the US on any given day. And those facilities have historically inadequate and life-threatening healthcare. COVID-19 has only increased the threat to the health of detained immigrants. There have been, ICE has documented over 400 COVID positive cases among ICE detainees, 8 deaths, 200 cases of COVID among ICE employees, and those numbers are likely far higher in reality due to a lack of any comprehensive testing. One HERC client was detained upon his arrival in the US. He was seeking asylum and he was detained right as he arrived. He'd been in detention for 16 months when the pandemic hit. And, you know, a group of students and I worked relentlessly to try to get him out of detention. It took 4 months before he was able to be released from detention. This is despite having serious medical concerns. He was forced to live in a dorm with, a room with 60 people in bunk beds. There was no social distancing that was practicable. He didn't have access to soap on the weekends. The situation was truly terrible. And if anybody expressed health concerns or symptoms, they were put into solitary confinement as the mechanism for isolating them from the rest of the population. We were lucky enough to be able to get him out after hundreds of hours of work that many immigrants don't have access to, that kind of advocacy. And there have been a number of lawsuits challenging immigration detention conditions during COVID and asking for the release of immigrants, but they've met with a piecemeal success. So in some places they've succeeded, and other places they haven't. The Immigration Clinic is currently pursuing litigation on behalf of a group of immigrants detained here in Massachusetts who are confined in similarly crowded quarters with lack of access to adequate soap, medical resources, with symptomatic guards. And the district court recognized how terrible these conditions were and yet refused to release these people who have families in Massachusetts and who pose no danger to the community. And the Immigration Clinic's currently appealing that case to the First Circuit. So what can be done to address the situation? I think there are some pretty simple things that could be done to address the situation. We could halt immigration enforcement. We could stop deporting people during the pandemic, which is also in turn spreading the pandemic across the globe. We could release people from immigration detention. There's no reason to be holding immigrants in these detention facilities. We need to protect the rights of the world's most vulnerable people during the pandemic, not use the pandemic as an excuse to continue to trample on them. Thank you.
Thank you, Sabi. Thank you very much. Let me remind our audience that you can submit questions if you like. And while we're waiting for those, let me start with a couple of questions. So Sabi, if I could ask you, the account you just gave us of the judge not appearing, of absence, shortage of lawyers, of dreadful detention facilities. COVID isn't going to go away no matter anytime soon, no matter what the outcome of the election. Assuming Vice President Biden were successful, what measures would you think could realistically and effectively be launched fairly soon to make conditions better?
I do think a quick and easy thing to do would be to release tremendous numbers of people from immigration detention, to reunite them with their friends or family members who could take them in, and to stop the spread of the virus in detention facilities. And there could be options for people to go forward via phone or video in court if they wanted to do so, and immigration enforcement could stop. So ICE could stop rounding up people and putting them in detention centers.
Thank you. And Jerry, let me ask you a question, if I might. Could you say a little bit about, since you're also an expert in international law, about how international law regards the type of suspension of refugee protections that you described the Trump administration having been engaged in? how to activate international law to address some of this?
Well, in terms of the content of international law, there are various aspects of the enforcement of the Title 42 system that violate United States obligations under the Refugee Convention, technically the Protocol to the Refugee Convention, and the Convention Against Torture, and the Covenant on Civil and Political Rights, all treaties to which the US is a party. Obligations under the Torture Convention and under the Covenant on Civil and Political Rights regarding return to torture are absolute and exceptionless. And the implementation memo of the Title 42 policy makes an empty gesture at complying with them because they know that they are absolute requirements, but without recognizing substantive or procedural rights. The Refugee Convention is not as absolute, and if it were truly necessary to close the border against all travelers to prevent the arrival of anyone who could conceivably be infected, then that would be permissible. But the US border policies are selective and are targeted against people who are in need of protection because they are unwanted by the government, not because they pose special dangers. And these policies can't be defended as necessary. The Title 42 system is also based on a policy of arbitrary detention, as Sabi was discussing. Arbitrary detention of asylum seekers for purposes of deterrence. The regulatory materials justified the rule in relation to the crowded conditions in the detention facilities, as I described. And from a human rights perspective, they shouldn't be held there in the first place. The rigid detention policies of the current administration violate international law norms against arbitrary detention. Now, bringing these international law claims to bear against the United States requires advocacy and persuasion. There are soft policies of accountability in the international system, but the United States avoids being subject to systems of binding adjudication of its human rights violations. And so it's the softer policy, it's the softer methods of international pressure and domestic advocacy that have to be used to bring this to bear.
Thank you, Jerry. And let me ask myself a question that's come in. What ought a new administration in Washington to do, assuming there is one, on the global stage to address the pandemic? So I think there are both short and longer term things related to what I spoke about earlier. So short term, with regard to the WHO, I mean, clearly the organization needs to improve several of its procedures. This is not assuming major surgery. What do I mean by that? Developing more of a capacity for independent monitoring of state compliance with, again, obligations that states have taken on themselves to report to the WHO about outbreak of disease. So it is possible. I mean, the International Atomic Energy Agency does have a much greater capacity to independently monitor state compliance. So that would be one thing. Another thing is right now the international health regulations are basically sort of red light, green light. Either a state has an epidemic and a problem or it doesn't. And moving to a more graduated system, at least a red, yellow, and green might be helpful. Why? Because right now a state's economic interests and its public health interests may be a little bit in tension. No state wants to, in effect, be a red light state and have all interaction influenced by that. Having what else, short term, the WHO not withdrawing, obviously would be one major step that a new administration could take that would be important. Completing what we're obligated to pay the US, between mandatory and voluntary governmental payments to the WHO, provides something on the order of about 400 million a year. That may sound like a lot of money, but believe me, it isn't in the area we're talking about. Longer term, as I tried to stress in my remarks, I think we should do these things because they're the right thing to do. But even if one doesn't care about that, just think of how much better we would be today if we were more mindful of helping bring up the quality of public health around the world, particularly in developing countries, that if we, in fact, could address better some of the implications of globalization. I finally can't resist, because I focus on China in my research, a comment or two about how all this has played out in the US-China relationship. So, you know, there's no getting around it that the nature of the Chinese system is not transparent, and that very much contributed to the initial spread of the disease. Sadly, the US response has been so poorly done that it's sadly given a field day to people in China who want to say to the Chinese population, look what happens when you have a democratic system. There's too much individualism, too much chaos, not enough attention to what's in the community good. Now, of course, the lie to that, or the response to that, is to simply look at Taiwan, which is democratic and has done a powerfully effective job of dealing with it. Anyway, enough from me. I see a couple of other questions. So one from Dean Minow to the panelists. Quite apart from what the US government may do, what may individuals do to improve the situation of detained immigrants and to improve US participation in global governance issues affecting COVID-19? So I'll turn that first to Professor Ardalan and Professor Neuman.
You know, one thing that individuals can do is that even when immigrants are able to gain their release through a bond hearing, they sometimes don't have the money to post bond to get out of detention. And so there are a number of bond funds across the country that have been hugely critical to immigrants in actually securing their release from detention once they're allowed to leave. So I think something that people can do is contribute to those bond funds, which are really important.
Great. And Jerry?
Well, I'll just add something on the subject of children, which is, you may recall, you, the audience, may recall the immense controversy over the family separation policy and all the publicity over the children in cages and so forth. There was a tremendous outpouring of public interest, public criticism, and mobilization of religious groups, as well as secular groups in favor of humane treatment of children. And that led to a change in the policy, not the elimination of the harms, the leftover harms of that policy or other continued harms, but it did lead to a change in the policy. Mobilization of public opinion in support of immigrant children is an area to which even the current administration has proven responsive, and so that's one of the things that people can do.
Thanks, Jerry. And let me throw in my quick observation. So I think Dean Minow is absolutely right that we simply can't rely on government, even if there's a change of government. As Sabi's comment suggests, as mine did, as Jerry, some of these issues or problems so long precede the current administration. So what to do? What can citizens do? So I think a couple of things. So first of all, I think it's really crucial to create greater attention here and elsewhere in the West about the implications of COVID in the developing world. You know, we're seeing it already in, you know, in Peru, Colombia, Brazil, but, you know, one wonders in South Asia and some parts of Africa, the devastation if the pandemic continues unchecked. And so for Americans to be mindful of that and to respond. So how to respond? So I mentioned before WHO funding, which is heavily reliant on charitable contributions. About 80% of its budget is other than the assessed contributions. And private sources, major American foundations like the Gates Foundation have done wonderful things. But it would be even more wonderful if, in addition to funding particular projects, as in the case of the Gates Foundation with regard to vaccines and polio, to also at the same time commit a fraction or part of additional support to funding core functions, particularly building up core public health capacity in developing countries more readily than is now the case. We have another question in the chat box. Let me grab this quickly. So Sabi, this is for you. It's a question from Morgan. What, if any, justification has been given for immigration courts staying open? Doesn't it seem like this decision is a result of the executive branch's stance on COVID and, you know, generally staying open? And how would you respond to it staying open as opposed to doing more remote or being imaginative in other ways?
I think it's a combination of the administration's response to COVID and also the administration's goal of deporting as many people as possible and moving forward with those hearings as quickly as possible, as record denial rates for asylum cases show from the past year. And, you know, I think I would just add to what I said in my last remark in terms of what can individuals do. I think continuing to shine a light on the conditions in immigration detention, on what's going on in the immigration courts is hugely important, because there are so many pressing things that are on the front page, the election being one of them. But these are issues that don't receive enough attention. And it does, you know, when family separations occurred, there was an outpouring of attention, but there's so much more that needs to be brought to light as well.
Great. Thank you, Sabi. We're just about at the end of our time. Let me turn, Jerry, do you have any concluding remarks? And then we'll come back to Sabi for hers, if any.
So just to underline what Sabi said about priorities, if there's a new administration, there are going to be a lot of things that it needs to change. And there's no guarantee of when it will get to some of the things that it would like to change. Public pressure may be very valuable in that. And to me, a big priority for a new administration should be restoring the rule of law. And this Title 42 system is a blatant assault on the rule of law.
Thank you. And Sabi?
I agree with Jerry.
Okay, and my last comment is I want us to be able to continue to reap the benefits of globalization here at Harvard Law School, in the US more generally, in the world. But with that has to come responsibility for addressing seriously its implications. I mean, you wouldn't think of building a whole set of houses out of wood without having a fire department. You need a way to address, whether it's about public health or about immigration or climate, the institutions that can deal with the inevitable downsides or implications of globalization. In any event, thank you all very much. Thanks to Sabi and Jerry and Emily and Martha, and behind the scenes, Jeremy and Ellie. And I'm sure all of us will be glad going forward, if you don't mind my speaking for Jerry and Sabi, to answer questions people may have. Thank you.